Hello, everyone. Thanks for joining us on SALTovation. Judy and I are here today to talk through and just kind of try to make heads and tails of what happened with the recent Colorado appeals decision that came out July 3rd. So, relatively recently, as of the date of recording. So, Judy, do you have any initial thoughts on what happened with Colorado and Netflix?
Well, what's fascinating about Netflix is they were my client at Deloitte when they had discs. And of course, they had physical presence nexus because they had their physical inventory, a disc sitting in my mailbox. So they had to collect sales tax everywhere, even at the destination level then. So they had capacity to handle the sales tax collection in Colorado because this is like 17 years ago they were getting compliant from that perspective. So it's interesting that they would even necessarily take this case up through the court system, but it probably is really more about like policy. And I believe that the CEOs of that time, I believe that was like kind of Jeff Bezos' time of, setting up Amazon and kind of being more strategic about taxes and being maybe a little more adversarial or changing the character of how the tax system is set up for sales tax in America and the states in general. So really the question was, is a streaming subscription corporeal, i.e. tangible personal property? And, we think of that as something you can touch, but it's something you can taste, feel, see. And we're leaning more on the non-touch, but on the taste. Not the taste, sorry. Well, you might feel a taste if you watch something, but the watch, the visual, that's your corporeal. So that is crazy because of course it expands to so many online things that you're experiencing and might be paying a subscription fee for. So, really also comes down to some legal issues of like what's an intangible versus a tangible item. Now, the case talks about intangible items being sort of like stock as opposed to the right to view. And I think there is a legal issue there about the right to view for a transitory period of time a video. But in the end, it comes down to the true object, which they didn't even mention, but I assume those are some of the briefs, which is what are you really buying? You're buying a video. How did you used to get a video? You got it with a disc, right? And then you put it in your video machine and you watch it. Now you just access it, your subscription with whichever the different streaming platforms there are in America, which is crazy that that's happened. I mean, we went from discs to no disc drives on any of our laptops anymore. Like we don't even have discs anymore. We completely transitioned to online saving of documents. Everything has really happened, moved away from paper to online. So, you're seeing this morphing in our economy towards this more tangential access thing that you pay a right to use it. And the state of Colorado is like, it's a thing. It's seeable. You have to tax it.
Well, and Colorado's always kind of taxed digital goods of,
Yeah.
we've been taxing
Ebooks,
downloaded ebooks, right?
music. Yes.
For a long
Yes.
time when just saying, hey, there's a shift from the physical, it's the exact same thing, but just in the delivery method doesn't matter. And so kind of how it took the streaming component to kind of be isolated.
Well, that's a
And maybe
temporary
it's just like,
access though. Think about
correct.
it.
It's
I download a movie, I keep it. I have a right to it forever. I can always access it in my account. I actually own it. So that's a
right.
purchase, right? Or even a rental of a temporary transitory. I don't know. I think it's a really, even within the concept of digital goods and whether you download it or whether you have access to it, I think those are the more fundamental issues where this corporeal, non-corporeal really should have spent time, but they didn't even bother to go there. They just said, you can see it, therefore it's tangible.
Right. Well, and kind of probably should have prefaced this first, right? The first round is Netflix applied for refunds.
Correct.
And so it wasn't even as if they got an audit and they had an audit issue,
Maybe. We don't know all the facts of
potentially,
the
right?
case.
So
Right.
they Netflix applied for a refund
Right.
for sales tax remitted. DOR denied it. They took
Yes.
it to, they litigated that first round. The courts ruled in favor of Netflix. And then the DOR appealed it. And so this
Yep.
is the appellate decision,
Yep.
that says that kind of reversed the first round saying, no, it's TPP and taxable.
Which
And
is
yeah,
really challenging for the tax-paying community to manage. I mean, we just keep seeing this broadening of the base based on our new economy, and more things are becoming taxable, arguably, and really giving departments of revenue broad interpretation authorities. I mean, I really, at first, I thought, no way, this doesn't go towards software. But of course, you can observe software
yeah,
physically. I mean, you're accessing it, you're looking at it, you're working in it. So how do we not go there? Now, we politically chosen not to tax software. We didn't. Then we were SaaS, and then we did for a very brief period there a few years ago, probably 10 years ago at least. And
yeah,
then we've politically decided not to. But what I am finding very interesting about some of these cases are we have the same words from 1935 being applied to today's business, saying the legislature back in 1935 anticipated taxing streaming, which is kind of what the court said because of
yep,
their concept of what they're taxing for sales tax purposes. So that to me was fascinating in and of itself. Really, in any way, shape, or form, if it's something that is taxable or corporeal, it's tangible, therefore it's taxable, not a
yeah.
service.
Because when I was reading it, I was when they were going through like, fundamentally in 1935 when Colorado enacted its sale, I was like, okay, here we go. Here's our history lesson. And then whenever you
Yes.
hear we're going to kind of focus on the definitions of things, and I was like, all right, Black law, here we go.
I know.
And then a
Black's
couple
Law
paragraphs
just.
later, it was the Black Law Dictionary, and the way that they ended up is saying like, hey, you're right, corporeal, your incorporeal property, it's a binary.
Yeah.
And so where they leaned is, right, well, incorporeal is in their definition, and I'm reading this, abstract rights that have no real existence perceptible to the senses. And so they're like, well, you can see a movie.
Mhm.
So it's not incorporeal, therefore it's corporeal, meaning it's tangible, meaning it's taxable. So
Yeah.
like where they got there and living in that binary is really interesting. Or
Because you
is
could
kind
have
of
even
where
said it's an amusement, and Colorado doesn't tax amusements. Some of our cities do, but the state doesn't. So couldn't that just be access to an amusement? I mean, you go to a movie, that is differently taxed than renting one at home. It's sort of irreconcilable a little bit, to be honest with you. I mean, really, for Netflix purposes, even now, I don't think it's so clear. And then if you were to take this Netflix case, you'd have Hulu, you have a lot of streaming services,
oh yeah.
Disney. I mean, there's a ton. When we morphed away from cable, now we have a ton of access with a lot of different products now versus paying a cable company to source them all for us. But where are they going to go next? Right. So I thought that was super interesting that this could really be a grab bag in our state of more intangible, what we think of as intangible products, as being corporeal, tangible personal property. So we don't have to change the law. We just can
Right.
tax it.
So, as we were kind of talking about kind of our pre-recording stuff, kind of we talked about this last paragraph, and I'm not going to read the whole thing, but kind of when they were thinking, kind of again made reference to the initial, implementation of sales tax. Um, This decision said the legislator obviously intended to tax such goods when passing the sales tax statute, casting aside nearly a century of historical practice simply because technological advancements have altered the specific form of delivery while leaving the product itself largely unchanged is a step that we are not willing to take.
I know.
So we're like, we're not going to dispute it. We're not going to argue it. We're just going to leave it be, live in that binary. And then, so now I guess I would ask you, Judy, what do you think is next?
Well, I do worry that there are other things going to be trampled upon, and we're going to see expansion of the base, arguably because you can see it or hear it. That's a physical presence, basically. So you're physically experiencing it. So I am worried. And what we've seen, even with the Wayfair law and a couple other things in our state, is we've seen an expansion of the base because of the words that already existed. And now we basically have a court saying, well, it didn't happen in 1935. I mean, I don't even know if we had movies in 1935. I have to look back at black and whites. Was that the time of who is the guy who had the little feet? Charlie Chaplin, silent film, right? When did film come out, right? So did it even exist in 1935? It might have. We might have had movies in the 1900s. So it could have been anticipated that you would go see a movie or have a movie. But we're really not even caring about that. Like, we're not caring if it existed in 1935. We're just saying it is this thing. So I think a lot of things could be reviewed, could be perceived by a Department of Revenue as a thing because it could be visually observed or heard as opposed
Well,
to
and
touched.
right. And we were talking, and I think maybe brought it up on a couple other videos, right? The Colorado legislator tried to tax non or download it in SaaS. We were trying to figure out like kind of that
Mhm.
non-physical software that Colorado's historically not taxed. That was a topic of conversation within this legislative session.
Yep.
It died, however you want to call it. It didn't pass, whatever. But
I don't
I
think it has
wonder,
to pass. That's the
well,
thing.
and
So
that's
they
what
could
I'm wondering.
decide
It's like, did
Department of
they,
Revenue can enforce. I mean, it wouldn't have to be a legislative change. Now, I think it's a better
right?
practice to make it legislatively clear that that is your intent, right? And then the Department of Revenue knows how to enforce. But we do see our Department of Revenues broadly enforcing because they're allowed to have authority over the laws and they
Yep.
get to interpret it with each unique business that they audit. So they always have had that power and authority, but how far can they take it? And I think this case gives the Department of Revenue very broad authority.
I would absolutely agree. So I guess we would say to our listeners, we're watching as you're watching. And if you have any questions, comments, concerns, want to talk, be a little more candid, um, reach out. You know where to find us at SALTovation.
Okay, so another upside of what we've been thinking about with the Netflix case is the cities already tax software, streaming, a lot of these digital things. So to some degree, you create parity with the Netflix case between the state and the cities. The disparity between our states and the cities, our home rule cities here in Colorado, is really a conundrum for tax-paying community, especially if they don't have software automation to manage it or even understand it when they're invoicing an end user. So that is one upside. And then another upside is we are seeing out of the 46 states, it's 45 states plus DC is not a state, it's a district. There are about 30 that tax software now. So we're seeing more trend towards taxing software than not. I would say California is one of the few holdouts in Florida, but they do tax downloaded software. So it's just SaaS. So you're really seeing this change anyway afoot. I mean, I've become more of a believer of like one rule applied the same way so everybody knows what to do. And I don't like that we have 45 rules plus one, and it's hard for taxing community to manage it and to look at that. I mean, it's created a career for us, but is that the best and highest way to get money from the people that are giving it to you, right? Simplification creates voluntary compliance. So anything you got from that, Mayor, that you think is an upside of the Netflix case?
I mean, it does kind of like layer in the consistency between the digital goods that we've always taxed.
Yeah.
Um, and so I think it's a matter of time that we're going to have potentially more uniformity between, both just within the Colorado department and, with our home rules.
I think it's just
So,
easier to know what to expect in a way, even though it's 8%. I mean, I was just in Michigan on vacation and their rate is 6% and it hasn't changed since 1996. I spent like $100 of $6 of tax. I like that instead of 10, so it is interesting the rates, but if you have a more uniform base, then you could have a lower rate maybe. I don't know. It is a conundrum, honestly, for raising revenue and the complexity we have in America with our sales tax rules, especially state by state, city by city.
exactly.
That's why you need
So
us,
that's why
unfortunately.
you need us,
Sorry.
right? Well, thanks again.